My name's Jules Winterton. I'm Director of the Institute. And this is one of a series of lunchtime seminars held to give an opportunity for our visiting fellows to present the research that they're undertaking at the Institute, their current research interests. I hope you all do receive notifications of our events. Presumably you do, because that's why you're here. If you don't, please do just give me a note of your email address. Now, I should introduce Judith Bannister, who's here from Adelaide University Law School, and she's got incredibly topical. Yeah, well, yes, it's in the newspapers today. So, the formal title is Accountability or Involvement, Open Government and the Participatory Ideal.
I slightly changed it, but
it has,
it's the same idea.
It has changed, right. which is good. It's a moving target. But yeah, freedom of information is really top of the agenda, both in terms of sort of current litigation and also thinking about how our new government will treat us or not. And I'm sure there's lots of things to talk about around that. So do feel free when we get to questions to open up topics. Over to you, Judith.
And I'd also say I'm very open to questions as we go along. I had particularly intended to talk about the spider letters, but we can talk about that at the end if you like. Now, I'm a visiting fellow visiting from Adelaide, South Australia, where we're going into winter, and the weather is, I'm told it from my folks at home, pretty much the same as it is out the window, so not missing anything. Okay, so a bit of an overview. I'm at the beginning of my fellowship here, so today I'm talking about just sort of the beginnings of what I'll be researching here, and some ideas about some underlying fundamentals for freedom of information law. I'm spending the next few months working through data that I've collected, and I'll tell you a little bit about that at the end. And at the book ending, this talk today is another one which I'll do in June, where I think will be sort of the equivalent, the sort of academic sabbatical equivalent of what I did in my holidays, when I'll actually tell you a little more about what I've done in the time I've been here. My research project I've called Thinking Spaces, and it's a comparative study of UK and Australian law, FOI law, particularly focusing on the exemption provisions in the two acts that deal with what in Australia we refer to as deliberative material, but here policy formulation sections I'll go to in a few slides' time. But basically the exemptions are concerning the protection of deliberative processes, the decision-making processes of government. So that's the general topic. But today, I'm looking at the problem that FOI faces, that applicants and public authorities, government departments and so forth, often have fundamentally different expectations about what FOI can achieve. Okay? And so I'm just going back to basics and asking why. What are the rationales or the objects of freedom of information? And I think the answer to the question, is disclosure in the public interest? And that's a fundamental question when you're looking at deliberative. It's in a range of the exemptions in FOI. But if you're looking at the exemption relating to deliberative materials, decision-making processes, the question is, it's a qualified exemption, it is subject to a public interest test. Is disclosure in the public interest? Your view on this can differ greatly depending upon what particular rationale you're focusing on. So that's what I'm going to talk about today. Now, just some basics, some groundwork here, and just sort of conceding for anyone. I've got a sense that I've got students and academics and so forth. I don't know whether I've got any government decision makers in the room, but I'll concede at the beginning that this is not a talk about the secret state or conspiracies or whatever. There is a natural disinclination to disclose. Now, I know that, well, I don't know, I'm going to date myself here instantly. I know that we live in a generation of tweet now, think later, and that we're all supposed to be on social media and talking constantly. But nevertheless, I don't know whether it's just me, but I think for many of us, there's, particularly when you're working in your professional capacity, there's a disinclination to disclose. Just step back and think, you know, really, how would I feel if I saw this on the front page of the newspaper? Okay, so there's a tradition of official secrecy. We've been saying that for years. I have to say this tradition is this very old one, long time ago in Australia. We've had freedom of information for over 30 years. This is one of the great areas where we beat the UK to it, about 15 years or so. So to say there was a tradition of official secrecy is a bit old hat now, but nevertheless, there was a long, long tradition of official secrecy. And also just an understandable caution or prudence. The idea of, you know, let's think about the implications of disclosure. There are practical realities here. Government agencies collect, create, store information, they keep it secure, and they know how to find it. And they have, let's be honest, control over how long it takes them to find it. Now, I know they're in the various statutory schemes, there are timelines and so forth, but on a practical basis, they are the record keepers. So there's a practical element here. And if we accept, as I think inevitably we must, that the public interest requires secrecy on occasions, there are circumstances where, you know, the national interest, public safety, personal privacy and so forth requires that material is not disclosed in the public interest. Once you accept that, there are fundamental problems and difficulties in the interpretation of that concept. So, perfectly understandable reluctance at times to disclose. As we'll see, there are democratic rationales for disclosure, and so what's required and what's been introduced in both jurisdictions is a legally compelled disclosure. It's freedom of information. And what's also required, and it's not the subject of my talk today, but along with that legal compulsion is a requirement of culture change, becoming more relaxed about disclosure. The other fundamental or starting point we just have to get over at the moment is that governments are different. That private individuals and entities, we have the perfect right to control our information, control what we disclose to the public realm. Now, again, I acknowledge Twitter and Facebook, and I just wish my students would think twice about the drunken photos they post and so forth. But that's within their control. They're not being compelled. There's a range of circumstances where we're compelled to disclose information to government and stuff. But public disclosure, there are very few circumstances where we are forced as individuals and as corporations and so forth, those of us in the private realm. There's very few situations where we're forced into the public domain. And in fact, there are data protection laws that enable us to protect our personal information. Executive government is looked at through quite different spectacles. That's a quote from the High Court of Australia. In a case, 1980, I'm going to think all these references back to the 80s. A very famous case in Australia of John Fairfax and the Commonwealth, where, now this was not an FOI case, this was before the FOI was introduced in Australia. It was a breach of confidence case, also a Crown copyright case as well. In Australia, we still have an equitable obligation of confidence. We're talking about who reforms first. Here, the UK is well ahead of us in Australia. The equitable obligation of confidence is what's being transformed into a wider, broader right of privacy here in the UK. looking at breach of confidence, and that case of Fairfax in the Commonwealth was actually in the days before WikiLeaks, it was a leaks case, so it was leaked foreign affairs documents, and it was fabulous in the old days of print, so they put water down the book and so forth, and because of the slow print run process, and actually because, I don't know, do we have any librarians here? I love this case because it was a librarian who sort of who drew the attention of the Commonwealth to the forthcoming of this book. Their publishers actually sent out advance notice to the libraries for pre-ordering of this book, and the librarian in one of the departments had said, do we want to buy this? And someone had looked at it and said, not only do we not want to buy it, we don't want it published, and that led to the case, and they got some injunctions. The point was made by Justice Mason in this case is that executive government is different. For individuals, the prospect of being forced, having information, your personal information, forced into the public domain, that in itself can be detrimental, can be harm. For government, in a democratic society, restraint on the publication of information is not advice in itself. It enables the democratic system requires that the public be able to discuss, review and criticise government. So governments are different. The starting point for governments is openness to disclosure. So that's a bit of starting point. Now I just thought I'd have a bit of fun at the beginning here. So given that I put that up there yesterday, it was up on the website. They had a clock running, 4 o'clock was when these letters were going to come out of the Guardian, and of course today it's in the newspapers. I'm not going to talk about the spider letters case, we can talk about later after the talk if you like. I just wanted to use these pictures to illustrate the media problem with FOI. The one at the top there, it's a South Australian example, and it's getting a bit older too, it's 2007, but I just love it. As an FOI officer, if you disclose to a journalist pages completely blanked out except for a couple of sentences at the top, you know it's going to be on the front page of the newspaper, in this case, page 7 of the newspaper. In that case, the journalist didn't get the story that he was after, but he got a story of official secrecy. Those of you wondering the Marge, it's a hospital. This is a dispute over the building. We're still building a new hospital and they were trying to get information about the costs of that. And of course, the other current example is the one with the Prince Charles's letters. 10 years it took to, they finally got their letters, but it took 10 years to get day. So, media are constantly critical of the FOI process. And there are many, it's been a whole lecture talking about the media critique of the process. What I want to look at today is this thought that there are fundamentally different expectations about what freedom of information can achieve. Applicants and public authorities have very different views on what ought to be disclosed. My research, as I think I mentioned at the beginning, is focusing on one particular ongoing tension that relates to the release of deliberative material, pre-decisional deliberative information. Now, I'm looking today particularly about the objects or the rationales behind FOI, and if stated broadly enough, we can all agree upon them. So it's easy to agree on grand statements, grand but vague, necessarily vague statements, but they're difficult to apply. So for instance, saying that citizens have a right to know is something that you get very little disagreement with, but it tells us very little about what exactly must be disclosed. In Australia, at the Commonwealth level, I'm not going to go into any detail about any of these statutory schemes. In Australia, as well as, of course, as a federal system, not only do we have the Commonwealth legislation, but we have a whole range of state and territory legislation as well. But the Commonwealth was the first to, Victoria, to go in 1982. In 1987, the Senate reviewed, 5 years in, have a review of how freedom of information was going, and basically they, on this particular point, they agreed that just about everyone was, in principle, agreed with how wonderful FOI was. There was generally widespread support for the Act. Now, one Australian, Queensland wasn't terribly fond of it in the 80s. They came round later on. But the Queensland government aside, and you can imagine privately a whole lot of government officials as well. But publicly, there was support for FOI. There was very little criticism publicly of its objects to make information available. This is a good news story. There was very little criticism of the idea of government accountability and so forth. However, there was some lack of agreement on the degree to which these objects have been achieved. So everyone agreed in principle. There was, and this is where the media, the criticism were coming in, not so much agreement on whether the objects have been achieved, but even more fundamentally, no real agreement on what those objects were. It was this controversy about whether or not it had actually fulfilled this. Now, this was 5 years in, we're 30 years in, and we're still having this debate. The controversy is exacerbated by the lack of agreement as the extent to which information in possession of government about its operation in principle should be made available to the community at large. Okay, so if you put it broadly enough, we all agree in open government, but there really isn't a lot of agreement on exactly what ought to be disclosed. And I think that's the fundamental problem. So I asked myself, what are the underlying rationales? Now, there's been some work on this. The UCL Constitution Unit here in London has done a major research project on FOI and the impact on government, and the House of Commons review cited that work. So this is my particular classification, but you'll see there are common themes running throughout it. Looking particularly at Australian sources, I divided it up in 3 ways. First of all, protection of private interest when you're engaging with individuals engaged with government. This is probably the least controversial part of FOI. So knowing what personal information is collected about you, this overlaps with data protection laws as well. But also knowing what rules apply to you, understanding how government works. If government's going to make a decision that's detrimental to your interests or is going to refuse you a benefit of some kind, knowing how the system works. Okay? So looking at it from private interest. Then there are a whole range of democratic rationales in a representative government, basically an informed electorate. One's generally sort of agreed upon. Accountability, I'll focus a bit more on that. Public confidence in government, got a question mark beside that. Again, from the Constitution Unit here in London, they did some work on this, and basically disclosure can actually reduce public confidence in government when you find out what's going on. My argument would be that at least it has the potential to increase confidence in the system, even though it may diminish your confidence in particular individuals involved in that system. As a whole, there's greater confidence in the system as a whole, there's transparency. So these are democratic rationales, and this is the administrative lawyer part of this, alongside that, improving policy formulation and decision making, so improving the processes of government through disclosure, that's an interesting one, and through direct public participation, and I've got a question mark beside that, and I'll talk a little more about that in a moment. Whether or not, as you'll see, public participation is mentioned as a rationale in both jurisdictions, it's commonly referred to, but I have questions about what exactly is meant when we talk about public participation. Now, I've put it there under improving government decision making, and it could just as easily be out under democratic rationales, but it depends on how broad you think that participation is. And I think actually what was intended was far more limited. than any radical idea of participatory democracy. But that's the argument I'm making by that. So I'm particularly focusing on these two ideas. Some of these others, the ability of individuals to understand how the government's working in relation to their personal interests is never as controversial as these big picture issues. So, under the UK, there's no objects or purpose clause, but drawing on extrinsic material, the House of Commons report in 2012 came up with these. You'll see there's a pattern here, so openness, transparency, accountability. Decision-making there is separate from public involvement. They've included public trust and alongside that. And then, again, the Constitution Unit at UCL has done some work on these very subjective objectives. There's no particular clause in the legislation. In Australia, if you look at the pre-legislative material, the purpose for introducing FOI in Australia was simply to introduce a US-style FOI Act. The 1966 American Act had major influence on FOI in Australia, and basically it took 10 years to come in. The Whitman government in 1972 promised a US-style FOI Act. So, I mean, as an object in itself, it was just basically, and then there were 10 years of debate over how you manage that in a Westminster system. Okay. But the objects clause that was originally introduced in 1982 basically was quite simple. It was to extend a right of access, and that right was, even in the objects clause, was framed by references to necessary exemptions. It was very cautious of sort of objects at this point. So a right of access subject to all these exceptions in the public interest. There was no reference to any underlying democratic principles or these broader rationales. As I said, in the UK here, there's no objects clause. It's very common to have an objects clause in Australian, certainly at a Commonwealth level, legislation, although, and that's generally thought to be a good thing to assist in statutory construction. However, if it's a cautious objects clause, it can lead to an interpretation of the provisions that weren't quite intended. So in 1995, the Australian Law Reform Commission, ALRC, and so along with the Minister of Youth Council, again, I mean, I could spend an hour, I'm going to send you all off to sleep over your lunch, but you can spend another hour talking about all the various reviews and reforms of FOI over the years. The ALRC expressed concern that the object clause was equivocal, too cautious, and that simply a right of access could be seen as an end in itself, and that meant that you could take a very narrow view of that right of access. A right of access wasn't seen as a mechanism implementing any broader open government principles, and this had led to a very narrow reading of the legislation and a cautious approach to the interpretation of access, greater emphasis on the exemptions. So, in 2010, there were major reforms of FOI at a Commonwealth level in 2010. One of them was to reform the object clause. There's more to it than here. It starts off with some general statements about access and so forth, but this subsection was included to make reference to these broader concepts of open government, increased public participation, which is I'm still puzzling about what they mean by that, and promotion of better decision making, greater accountability, and so forth. This was introduced in 2010. Just offered a little aside, that's not what the talk about here is today, but it's budget time home in Australia. And there were other reforms introduced in FOI in Australia in 2010, one of which was long-awaited introduction of an information commissioner at a federal level. So although we'd had FOI for a very long time, there'd been no information commissioner. The information commissioner lasted less than 5 years. Last year, there was an attempt to disband the office. And the reason that the budget's critical here is that the first step was all funding was cut for the office out of the budget last year, and then a legislation was introduced to disband the office and go back to a system of review by the tribunal, but they didn't get it through the Senate. So for a year, we've had an information commissioner, a statutory office holder, with no office, literally no office, no staff. And here we are, we're back. It's a year later, and there's some, I haven't read it yet, there's some slight mention of it in the budget. But so there you are, we have an information commissioner who's not an information commissioner in any sense, in office, which is completely off the point here. But so in Australia, it's FOI is controversial as well at the moment. Back to my point, in 2010 the objects clause was reformed, and that's not been changed. Any changes in the information commissioner. Okay, now there was a subtle difference in the wording in relation to the concept of public participation. The recommendation of the IALS was this broader democratic concept, enable people to participate in the policy, accountability and decision-making processes of government. What was actually enacted was increasing public participation in government processes with a view to promoting better informed decision-making. Okay, so I think this far more cautious approach is basically participation involved is to inform the decision-makers, not to have any form of direct involvement, as you might sort of hope by the first, to be directly engaged in any way. And so this leads to the question, well, what is meant by public participation? Lots of work on this in the political literature. I've chosen this because it's just a nice sort of graphic illustration of my point. But participation could be anything from very minimum participation. Now, this Shandar put information down there. I'd have a whole discussion about what's meant by this information there. If it's simply passive receipt of information, then that's hardly participation at all. I'd argue, and they don't consider FOI in this, but I'd argue that FOI is more involvement than that, because it's the ability to compel disclosure, so it's to demand access. So it's further along, but it's not nearly as far along consultation, right through to direct theories of direct participatory involvement in the process. And just by referring to public participation in this broad sense, I think what we've ended up with is a mismatch in expectations about what open government can really achieve in the FOI context. So, whether or not we've had promises emerging from theories of participatory democracy. Now, participatory democracy is a sort of a radical concept emerging from workers and students groups in the 60s and 70s. And I've written a paper on this in more detail with some authorities on this, but it's been transformed into something almost mainstream nowadays, where you have business talking about participatory democracy. You sort of have to think that they don't really mean that level of worker participation as was intended by the radicals of old. But local government, it's a catch cry, but it doesn't really mean the kind of participation that was originally envisaged. I also looked, as I say in the paper that I've got under review at the moment, looked at other political theories of, and particularly of deliberative democracy. And I think this is closer to what is probably meant in an FOI discourse about participation. Now, in deliberative democracy, you have a separate sphere. So you have the private sphere, you have the sphere of government or state, and this third civil society or public sphere in which there's open, rational discussion that's conducted. Now, I'm very conscious of the critiques of the various theories of deliberative democracy that, and I'm not advocating it as such, but I think this is the idea that it's closer to when it's talked about in FOI discourse. So I'm very aware that the critics of deliberative democracy argue that it silences minority voices, that there's a feminist critique of the private realm and so forth. So that debate aside, I think actually when participation in terms of freedom of information is discussed, what's really meant is the ability to compel information into the public sphere and then to talk about it, not any sort of radical participatory involvement in the decision-making process itself. And I think there's a mismatch in expectations because of this just broad use of the concept of participation. Now, talking about information commissioners, this is a quote that I'm about to put up in a moment. It's sort of broken up because I know many years ago when I was beginning my career in academia, we did PowerPoint displays. We were told I need to put 6 points up on PowerPoint because none of us does that anymore. I'm going to put up in bits to pretend that it's small. But it's a quote from Professor John McMillan, who is still Australia's Information Commissioner, and a lifelong advocate for freedom of information. As a young academic, he was involved in the original sort of push towards freedom of information. He was the Ombudsman and then the Information Commissioner. So when you look at this quote, you have to realise that this is a quote from an experienced Information Commissioner with a long tradition of advocacy for openness, and yet at a seminar at AAU in Canberra, he made this statement. There's an apparent assumption underlying some freedom of information requests, often framed as requests for all drafts, emails, briefs, file notes, like everything, is that the requester believes they occupy a notional desk alongside the agency officer and a right instantaneously to comment upon or participate in every transaction. This is not a sustainable model for effective government in a complex age. I'm not entirely sure it's a sustainable model ever for government decision making. Now, this is not a quote from an old school bureaucrat who just had problems with FOI. This is from the Information Commissioner. And I think this quote's very interesting because I think it suggests that with some applicants, there is this unrealistic expectation of complete involvement in the process. Now, not the Commissioner, but I think such applicants would be somewhat naive, given that the length of time it takes for these things to be processed, 10 years if you're the Guardian, you're never going to get involved because it's all going to be over by the time you get the information. But that aside, there's an expectation of participation in the process. Whereas I think that what really was intended was simply participation by compelling disclosure of information and then talking about it and influencing government by that public discourse. So, there's particular problems, and this is what I'm focusing in on my research, in FOI and the decision-making process. There's absolutely no problem, and any administrative lawyers amongst us would be aware. Nowadays, there was a time when giving reasons for decisions was a radical idea, but nowadays, the idea of making a final determination and giving statement of reasons is a routine part of government decision-making. And unless there are other exemptions, and if we're talking here about public disclosure, then obviously personal information and so forth would be an exception there. But the real question is, what about these records of the decision-making process themselves? The communications between the collective decision-makers, all that sort of backwards and forwards of should we do this or should we do that, and really what are the implications of this and so forth. The pre-decisional advice and recommendation that's made to decision makers, and this is often to ministers and high-level decision makers. And so these are the exemptions that legislation up on the screen for today's talk, but I'm looking at both the deliberative documents exemption in Australia and the two sections in the UK Act on formulation of government policy. Not until this morning, until the Supreme Court case came out, not particularly at communications in the monarch. Yeah. Okay. And so when we're looking at disclosure of these pre-decisional materials, then the question is, if you start, as I did right at the very beginning, from a presumption of disclosure, governments are different, the starting point is disclosure and there's a reason not to. What is the harm in disclosure of deliberative material? Why not? What harm will it do? And this is another review. Look, these are just sample reviews, as I said, they're endless reviews of FOI. So over the years, a good career has been had by a number of people just sort of commenting on all these various reviews. One comment that was made in the review in 2013 was that there was an absence of a clear indication of the harm that this is exemption for deliberative materials, is designed to protect. No one really knows what the harm is that this exemption is protecting us against. And this means that the exemption is subject to different interpretations and difficult to apply, which is a polite way of saying the government thinks one thing and the applicants think something entirely different. But there's no general agreement about what the harm is. Now, for those of you who are decision makers, and even though we might not have any government decision makers here necessarily, I mean, any of you who are academics, we all make decisions to decide what mark to give and whether or not to accept an extension application, and higher up, I'm sure there are endless sort of decisions that we make within the sector. There are the arguments that are made against disclosure of this deliberative material is that it could undermine negotiations with a third party. Now, some of these are time sensitive, so that's absolutely right. Two, if you're engaged in the contract negotiations, then at the time, the disclosure is going to cause a harm. So you can see a harm in some of these. The information might be price or market sensitive again. This is time sensitive information. Now, these are becoming more controversial. This is a commonly made one. Decision makers need a safe space to work through options and formulate policy. Okay? And that arguably is a time-sensitive one as well. That actually, particularly if you're collective decision makers, you need to exchange views. But even if you're a single decision maker and you're being advised, there needs to be a time and a sort of safe space to just work this out. If you're an individual, you can do it in your head. You can sit down and think about this and not tell anyone all the things you've weighed up until you come to a conclusion. If you're a group of collective decision makers, you have to talk to each other, and the modern reality is that conversation will lead to documentation, which will potentially be subject to FOI. Arguments, and this is particularly at high level, disclosure may undermine collective decision making in the sense that you get to see if someone gets from the outside, gets to see the personalities and plays them off against each other. And this is the most controversial. This is one that I'm particularly focusing in on. Disclosure may reduce frank advice and record keeping in the future. And these arguments about harm to the future is the most problematic of these arguments. Some idea of, if you make us tell you, we will stop, I don't quite know what, we will stop talking, we will stop providing frank advice, or we will stop writing it down. Now, from Australian perspective, I have to say we've had FOI for 30 years and they haven't stopped writing things down, but nevertheless, this is an argument that's made. And it's a matter of timing with a lot of these. And I think also that the argument that I've made today is that what conclusions you come to when these arguments are made can also depend upon the purpose of the object that you ascribe to open government. if it's that more radical form of participatory involvement, then there are really great expectations about real-time disclosure. However, I think really, if you focus in on accountability as the sort of the primary object, then the decision-making process, the safe space can be protected and accountability can be satisfied by disclosure after the decision has been made. So you at least give a safe, temporary safe space, but ultimately there will be disclosure. I think I've already made this point, but claims about future harm are particularly problematic. And so what I wanted to emphasise is the accountability rationale. So basically, decision-making in a safe space. Accountability means. So, and as I said, this is my thinking at the moment, and I'm keen to have a discussion with everyone. Later on, I'll get to tell you what I've done while I've been here, and that's my next talk in June about this further work on deliberative matter. What I'm doing actually is working on documents. I've done meta requests, so I've FOI'd the FOIs to see when, in some agencies, not across all government obviously, but in selected agencies, to look at what kind of material is being refused on this particular ground of deliberative material. So, that's basically what I had to say.
Judith, thank you very much indeed.